Well, Sarah Boone asked for a new lawyer, and ye shall receive when ye asketh. She's on her 9th attorney, and we're going to talk about it in today's video. Hello, Sofa Squad, and welcome back to the sofa. Sofa's back there, Paul's right here. Now, what we're going to be doing today is discussing, I can believe it, but I also can't believe it. We're going to be talking about an update in the Sarah Boone case, trial, saga, whatever you want to call it. Now, what this update is Sarah now has another attorney. Okay. She is on her 9th attorney now. Depending on when you're watching this, I'm recording this on September 2nd. They are having a hearing on the 3rd, I believe. We'll obviously be going over that. She has an attorney. I mean, there's just nothing else to get around it. So they've asked for a continuance and they got discovery, all that stuff. So what I want to do in this video particularly is look at his website, just kind of go over who he is a little bit, look at a few of the motions that have been filed. Now, before we even get into it, okay, if you're new here, or if you're not new here, keep in mind, I'm not an attorney, I'm not a police officer, I'm not an investigator, I'm not a therapist, a lawyer, anything of that nature. Okay. I'm just a guy with a sofa and opinions on true crime based on all this public information that's out there. So just keep that in mind. These are just my sofa speculations, as I call them. And that's it. And all this is alleged, of course, because she has not been convicted yet. Now, if you're unsure of what this case is, if this is your first time coming across it, Sarah Boone has been incarcerated for, I think, 5 years. It could be even a little over 5 years at this point. In county jail, she has been accused of taking the life of her now deceased boyfriend, George, by, I don't even know how you would say it. I don't even say by strangulation. Essentially, she somehow allegedly got him into a suitcase. He could not get out. He begged for her to let him out. She didn't. She mocked him. She recorded it on her phone, and he eventually succumbed to being in there and suffocated. So that's the nuts and bolts of the case. This video is not meant to be some kind of like real deep dive into it. This is just reviewing these new updates in it. So anyways, let's go ahead and get into it. Let's first look at the attorney's website, just some little screenshots I took of it so we know who we're talking about. Okay, now as you see, his name's James Owens, attorney at law. He's located in Milton, Florida. It says, build a solid defense, meet with James Owens, attorney at law to discuss your case. If you're facing criminal charges, every second counts, it says. If you jump down to the second paragraph, it says, as a top Florida trial lawyer since '86, James has handled countless cases from simple misdemeanors to serious felonies. He'll help you understand your rights and explore every legal option. Now, we'll see how that comes into play with a case like Sarah's. Moving on, it just goes into, why should you pick him? 35 years experience in the courtroom, knowledge of both sides of law, convenient virtual consultations, text availability, personalized legal strategy with proven results. He's taken over 100 jury trials to verdict. Now, some things that jumped out to me right here that probably had Sarah going bing, 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 bing. Okay. And this might come to bite him in the butt, y'all. The third one down. Convenient virtual consultations and text availability 24/7. Let me tell you what, if he didn't mean that one, he's getting ready to find out. Okay, just saying. He's getting ready to find out. We're getting ready to put that one to the test, okay? Let's look at the last page real quick. It says there's no case too complex, and it just lists the things off here, which you can see towards these end, the last few of the bullet points, how this is probably aligning with what Sarah's wanting to do. Now, let's take a look at some of the motions that have come up. Now, this first one is just the defense motion for continuance, and it says, we're just going to go through it. Comes out of the defendant, and it goes into that. Now, let's just read these off. The defendant is set for a jury on jury trial October 7th, 2024. It says the defendant has just retained defense counsel. Notice of appearance was filed August 30th. 38 days before trial, defense counsel has met with the defendant 4 times at the Orange County Jail between October 20th, 21st, 26th, 27th. During these meetings, the defendant disclosed potential exculpatory evidence on her phone in the possession of the Orange County Sheriff's Office. Evidence includes photographs, videotapes, calendars, text messages, notes, and witness names and numbers. This evidence will potentially corroborate her anticipated battered spouse syndrome defense under Rule 3.201 of the Florida Rules of Criminal Procedure. Undersigned counsel has spoken with numerous potential expert witnesses covering a range of possible defenses. Counsel is also actively vetting several additional experts under directives from interested parties. Very interesting. So this tells us right here, 100% she's going for that battered wife syndrome. a battered spouse, whatever it's called. That's clearly what she's doing here, right? She has found an attorney who seemingly is listening to everything she says, right? I find that very interesting. Let's keep going. It says, it's the professional opinion of counsel that the retention of one or more of these experts and the development of the aforementioned defenses is crucial and necessary component of the defendant receiving full and competent representation and due process under law. Based upon the conversations that have occurred, counsel has learned that proper diagnosis and development of said defenses requires time, not only for administering appropriate testing, but also the necessity that any expert testifying on behalf of the defendant be given adequate time to establish a trusting relationship and then be allowed to apply the analytical tools to the information developed from interviews with the defendant and supplemental with historical and documentary information from third parties. So pause right there. This is where it gets tricky because, I mean, with what the lawyer's saying, yeah, any lawyer coming on here and starting this, I agree. But it's like, what is this going to do to the case, okay? Because this could literally just go all the way back over again. I don't know if she's trying to get them to say time served. I don't know what the end game is. If she's trying to completely get it just gone. Because I'm like, do you just want to sit in county jail for like 10 years? I mean, what's going on here? Okay, so number 9, the process is described to the undersigned counsel by renowned and respected experts cannot be accomplished in the time available before trial, particularly given the JAC ministerial hurdles. I can't get that word off my tongue, but which must be cleared when dealing with an indigent defendant. Notice of intent to rely on the battered spouse syndrome defense must be filed 30 days before trial. The notice must be filed by September 7th, 8 days away. The defendant has been deemed indigent for cause. The defense will need government funds to assist in paying the experts in this field. Defense motions will need to be filed concerning the potential Brady material. The defendant has the right to be represented by counsel of her choice. The defendant attempted to solicit private counsel after the court's order dated June 28, 2024, and the defense counsel responded to her advertisement and was retained. I cannot. Oh my gosh. Y'all, I'm sorry. Okay, this is the first time I'm reading through. Oh, I just spit everywhere. I apologize. This is the first time I'm reading through this. I mean, I saw people making jokes, and I even made the joke in the beginning talking about she put the ad. I didn't know it was legit. Oh, help. I didn't know it was legit. I mean, damn. Oh my God. Who am I to talk down about somebody? Okay. To just put out in the universe. Yeah. Your dreams can come true. Whew, okay. Okay. Whew, okay. We are having a hot flash. Okay, here we go. There we go. Okay, let's get it together. Okay. The defendant is not trying to delay the proceedings or abuse the process by retaining counsel at this late date. No, not over here. We don't want to go to the briar patch, not us. Right? The defense certifies this motion as made in good faith. Okay. Memorandum of law. Now, this is interesting, okay? We go back into the Sixth Amendment thing here, right? The Sixth Amendment in the U.S. Constitution guarantees that any person brought to criminal prosecution in federal court must be afforded the right to the assistance of counsel. It just goes into the Sixth Amendment stuff and whatnot and getting the account. So I'm not going to read through the whole thing here. You can pause to read if you want to go in that, but I do think that it's interesting that this comes up again. Now, obviously, this is from a legitimate attorney, not just random people or whatever, right? So there is that. Now, you see at the bottom, it is signed by James, Florida bar number, address, all that fun stuff. Okay, now let's go on to the next motion, and this is the statement of particulars. Okay, so now it just says in the beginning here, like we do, here comes the defendant, all that. So let's go down to number 1. It says the defendant, Sarah Boone, is charged by way of an information with a single count of second degree M. The pertinent part of the information states charges that Sarah Boone, on or about the 23rd day of February 2020, in said county and state, did, in violation of Florida statute, by an act eminently dangerous to another and evincing a depraved mind, regardless of human life, did kill George, it's however you pronounce it here, George Torres. Now we go down to number 3 here, and let's just get into the highlighted part. To prove the crime of second-degree M, the state must prove the following 3 elements beyond a reasonable doubt. And it goes in here that the victim is deceased. Number 2, the death was caused by a criminal act of the defendant. Number 3, there was an unlawful taking the life of the victim by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. And then it goes into the definitions here. And it says an act includes a series of related actions arriving from and performed pursuant to a single design or purpose. An act is an eminently dangerous to another and demonstrating a depraved mind if it is an act or a series of acts that, number 1, a person of ordinary judgment would know is reasonably certain to take the life or do serious bodily injury to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree M, it is not necessary for the state to prove the defendant had an intent to cause death. Number 4, under Florida rules of criminal procedure, a defendant has the right to know of the charges against them with specificity. Specificity, that's another one I have a hard time with. Upon request, the state must provide specificity. They're going to use that 100 times now, right? Okay. And clarification on the details of the alleged offense in order to minimize surprise at trial and ensure that the defendant's rights are protected. Number 6, the rule requires the information on which the defendant is to be tried shall be a plain, concise, and definite written statement of the essential facts constituting the offense charge. Number 7, the information fails to inform the defendant of the particulars of the offense sufficiently to enable the defendant to prepare a defense. Wherefore, the defense would respectfully request the court consider this request and grant the defense motion for statement of particulars. So, I mean, there's that, okay? We would expect a lot of the same stuff is just going to just happen again, right? Because that's where we're at. Now, last but not least, let's just look at this other one that says it's about the discovery. So notice of provision of discovery, and it says comes now the state of Florida. The undersigned assistant attorney gives notice of below exhibits have been disclosed to James Owens as follows. The following have been sent electronically on August 30th. Discovery pages 1 through 421 and witness list records. And then the following digital evidence is available for copy, and it goes into like the 911 call, interviews, videos from Sarah Boone's cell phone, public surveillance video, photos, suitcase video and device photos, ME photos, audio interview with Brian Boone, Sarah Boone interviews, cell phone videos, USB 3D scans. Please provide the respective media type for disclosure copies upon request. And then it says, I certify that a copy hereof has been furnished to James Owens, and it just goes into the details there. Okay, so those were all the things that were up when I checked them out, right? Here's my thing. So there's two things going on here. Yes, at the end of the day, as a spectator of trials and criminal cases and whatnot, yes, it's like, oh my gosh, we're right here at the finish line and here we go, right? Now, that's, the superficial dynamic of it, right? It's frustrating. Yes, it feels like she's abusing the system. Yes, it feels like there's an end game here. I mean, of course there would be, right? For any defendant, regardless of how he might feel about their guilt or non-guilt or anything like that. Here's the clincher to it, though. At the end of the day, whether she's playing a game or not, she has the right to counsel. And she has lucked out with this dude who has reached out to her for whatever reason. Who knows? Whether he either thinks she's a sitting duck, he wants clout, who we don't know, right? I mean, we know he's probably not going to be getting money from her, okay? I mean, she doesn't have anything. The big question is, for me, is this going to completely just restart this process over, or is the judge going to be like, you have 30 days to hurry up? I don't know what happens in criminal cases like this, where it goes year after year after year after year, and she's exhausted. I mean, she is costing so much money to the, I don't know what you call it, the county, the system, whatever, by doing this. Also, Here's the biggest difference with this. This is the most, at least for me, transparent that I have seen an attorney being with the motivations. This to me is showing this is what she's been asking for this whole time, right? So for whatever reason, these other 8 attorneys that she had, that either they weren't buying this story from her, they weren't going for it, who knows, okay? But are we going to see a difference with this? I don't know. If she runs this man and his law team, you know, like whatever you call it, ragged, he might be like, psh, get out of here. You know, I went and looked at his reviews, and he's already got a couple up there that are talking about, you know, this is 5-star reviews or whatever they are on Google, talking about, wow, you know, he's really gone to bat for this woman, and this is a really difficult case, and, you know, this shows what a good attorney he is. Now, who knows if those are real or legit or whatever, you know, but again, it's going to be curious to see if he can handle Sarah, if he can handle this case. The defense that she's going for, clearly in her mind, she is saying, I have enough evidence on my stuff to show that I was a battered spouse and did whatever I had to do to get out of it. My question will be, will that defense hold up in light of the fact that you have him in the suitcase on video begging for his life? You're, meaning Sarah, is probably blackout drunk, there's something going on. She ends up dying. Then all the interviews after that she did, where it's clear she had no recollection or thought she deleted it, something of that video. So when you look back, and I don't know the cases off the top of my head, but like cases where these women, and there's this one woman I'm thinking of, if you know it, drop it, where it was very famous. She was behind bars for, I want to say decades, and I feel like she's out now. But she ended up killing the dude. And if you watch like the content, the documentaries on it, stuff like that, you literally are left like this. You're like, there's no, it gives me goosebumps. There's no way this woman was going to escape this dude without him killing her. There was no, I might not be in his presence here, so I'm going to run to the cop. She did that. She exhausted. This man was going to kill her. And then it all came up to a moment. She kills him. She did what she had to do. And she gets charged and spends, you know, a long, long time in prison. I don't get that vibe with this case, but I don't know the evidence. I'm not privy to it. I'm not going to be on the jury. None of that stuff. So I will say that, you know, I haven't watched a documentary. I've just watched it unfold, right? So I haven't seen Sarah produce anything or anything out there yet. And again, time will tell. That's going to show she was completely held captive by George. You know, this was her only out, was to get drunk and paint and draw and then lock him in a suitcase and go upstairs and pass out. Okay, so that was her only way to escape this man, okay? If she can produce the evidence in that way that shows, wow, we were wrong, like, whoa, okay, then hey, I'll take the L on that, right? Do I think she will? Not so much, but you know, again, we'll see, right? I think it's, you know, I think it's amazing that an attorney is taking this on. I want to see if he will be able to carry it through. And again, we're just going to have to see. The biggest thing right now is how is the judge going to react to the continuance, and what kind of continuance is he going to give? So that's it. If you're still watching, I greatly appreciate it. Please let me know what you think in the comment section of the attorney, the whole thing. Do you think he'll continue meeting the judge? Probably by the time you're watching this, within hours, we're going to find out, right? So that's it. I do appreciate you watching. If you are still watching, or if you stopped watching a little bit ago and you're telepathically hearing this, well, I appreciate what you did watch. But that's it. Drop some sofas off for myself and Rosco in the comment section to talk about this case and all the other things we talk about here at the Sofa Squad. And until we meander our way down to the comment section, I'll see y'all soon. I just wanted to say thank you again for watching the whole video, and also thank you for being part of the Sofa Squad. Special thanks to all the Patreon members, channel members from both of my channels, everybody who likes, shares, subscribes, comments in the comment sections. It helps the channel out so much. Now, don't forget, I do have that other channel, the podcast channel. That's where we go live, we hang out, we talk. We have kind of sort of a schedule, but just be sure and check it out. I'll put it up here on the screen. Also, if you're looking for merch, be sure to check out my Teespring store. I'll put that up here. And then, like I said in the beginning of the video, if you want to follow me and Rosco on the Instagram, go on, check it out. It's right here on the screen again. But once again, thank you very much. I really appreciate you being part of the Sofa Squad, and I'll see you in the next video.